All right, folks, let's cut through the noise. While D.C. stays wrapped up in legislative games, executive moves, and headline-chasing politics, what too many people miss is the quiet war still raging at the state level. Beneath the surface, states like California are working daily to grind away at the rights of law-abiding gun owners. That's not new. If you've lived there, you already know the drill. Stricter laws, more red tape, and a culture that seems determined to push the Second Amendment to the margins. But every once in a while, the script flips. Not just another defense, but an actual win. Not just a stall in the assault on our rights, but a decisive victory. And that's exactly what just dropped out of the Southern District of California. Let's break it down. Just a couple weeks back, on July 1st, 2025, a federal judge down in the Southern District of California handed down a decision that's already shaking the ground nationwide. The case? Hoffman versus Bont. And the verdict? California's ban on non-resident carry. Unconstitutional. No half measures. No delays. Judge Kathy Ann Bino didn't issue some temporary injunction. She dropped a full summary judgment. That's a hard stop. Game over for a law that's kept lawful Americans disarmed simply because they didn't have a California zip code. Now, let's be crystal clear. This wasn't about carry permits for California residents. It had nothing to do with locals applying through their counties. This case targeted the flat-out ban on non-residents. People legally licensed in their home states, well-trained, background-checked, cleared to carry, shut out solely because they didn't live inside California's borders. And here's the kicker. California's legal team argued that non-residents weren't even the people as defined by the Constitution. Yeah, you heard that right. They claimed constitutional protections didn't apply to Americans from out of state. That kind of argument should light a fire under every freedom-loving citizen in this country. Thankfully, Judge Beno saw through it like laminated glass. She didn't just disagree. She ripped the entire foundation out from under their logic. In doing so, she didn't just strike a law. She opened the door for challenges far beyond the West Coast. What separates Hoffman versus Bont from past wins is scale. We've seen victories before, but most of them were narrow. They helped individual plaintiffs or small groups. The impact stayed boxed in. Not this time. This wasn't relief for a few. It was a direct challenge to the law itself. And that law? Gone. Declared unconstitutional from top to bottom. No more blocking non-residents from even applying to carry in California. The whole statute's been invalidated, and that ruling applies across the board. Even bigger than that, this decision forces a national redefinition of what the people means under the Second Amendment. It tells every state out there, you don't get to strip away someone's rights just because they crossed a state line. That's not how liberty works. Constitutional protections follow the individual, not the geography. And that precedent? It matters. A lot. Now look, some folks might brush this off as just another court ruling, but let's not miss what's really going on here. This isn't about technicalities or red tape. This is about the court standing up and reaffirming something we should never have to question. Constitutional rights aren't privileges you earn based on where you live. They're guarantees. Period. No footnotes. No asterisks. Yeah, this case was filed in California, but the effects? They stretch far beyond the state line. By striking down the ban on non-resident carry, the court just sent a loud and clear message to every other state playing the same game. You build laws on residency to block people's Second Amendment rights? You're on borrowed time, because that kind of exclusion won't hold up under real constitutional scrutiny. This isn't just a win for folks who want to visit California and carry. This is a warning shot to lawmakers nationwide, those who treat the Constitution like a menu they can cherry-pick from. The ruling builds directly on the legal foundation set by the Supreme Court in New York State Rifle and Pistol Association versus Bruin. Remember that one? It made it absolutely clear. The right to carry is not some second-tier freedom. It's not something states get to deny just because they feel like it. And this latest ruling? It pushes that principle even further by applying it directly to a full-blown statewide ban. Even more important is what this means for future Second Amendment cases. Hoffman doesn't just reference Bruin. It weaponizes it. It uses that logic and applies it to real-world legislation, giving lower courts a playbook to follow. That ripple effect? It has the power to shift how 2A cases are decided all over the country. And here's what matters most. It proves you don't need a Supreme Court spotlight for a decision to move the needle. Some of the biggest changes start in district courtrooms, far from the cameras. That's where constitutional clarity is born, quietly, strategically, and with ripple effects that reach across state lines. Because the truth is simple. If your rights can be denied in one zip code, they're at risk in every zip code. Now, let's talk reality. Not everyone's thrilled. A lot of California residents are fired up, and I get it. You play by the rules, fill out the paperwork, pay the fees, jump through every hoop, and still get stonewalled by your own county. Meanwhile, this case hands a win to out-of-staters. That stings. It feels disconnected, maybe even useless. But don't miss the big picture. Because what just happened here? It shifts the battlefield. By saying the state can't gatekeep rights based on residency, the court took a sledgehammer to the legal excuses California's been hiding behind. And that has consequences. If non-residents can't be discriminated against, how do you justify all the county-by-county games being played against people who actually live in the state? How do you defend endless delays, random denials, and systems that change depending on your zip code or your bank account? This ruling doesn't rewrite California's resident permitting system, but it arms future lawsuits with a constitutional wrecking ball. It sets a legal precedent that can be used to tear down arbitrary, geographic discrimination built into the permit process. And that's not just theory, that's strategy. So while this ruling might not kick the doors wide open for Californians just yet, it absolutely cracks the frame. It creates leverage, new arguments, new openings to dismantle the carry restrictions from the inside out. If you're a gun owner in California, this isn't the endgame, but it's a starting point that matters. Now here's the twist. California's legislature isn't backing off. Not even close. As the courts start chipping away at the state's anti-carry fortress, lawmakers are already trying to rebuild it. And they're doing it through a new move, Assembly Bill 1078. You've probably heard the buzz. Most folks are talking about the headline-grabbing limit on firearm purchases, 3 guns per month. That's a direct response to courts striking down the old one-a-month law. But buried deeper inside AB 1078 is something just as dangerous. A brand new framework for non-resident carry. Here's the catch. If passed, AB 1078 would technically allow non-residents to apply for permits. Sounds like progress, right? Wrong, because every inch of that permission is buried under layers of state control. We're talking mandatory psychological evaluations, mandatory live fire training, steep fees, county-specific paperwork, and short-term expirations. It's the same red tape that's been choking California residents for decades, and now they're exporting it to everyone else. On paper, it looks like compromise. In reality, it's a trap, a strategic end run around the court's decision. If California can say, look, we fixed it, we have a process now, then they can argue the courts don't need to get involved anymore. But that's not fixing the problem. That's disguising it. That's how bureaucracies hold the line, by changing the label, not the behavior. And that's the real danger. AB 1078 isn't reform. It's resistance dressed up in paperwork. If this bill becomes law, it could gut the momentum we just gained. The state will pivot the narrative from, is this law constitutional, to, we've already addressed that in new legislation. And that's a problem. Because the rights we're fighting for don't need to be repackaged. They need to be restored. Fully. Clearly. Permanently. That's why AB 1078 demands close scrutiny. It's not just another bill. It's a tactical counterattack. And if we don't see it for what it is, we risk losing ground we just took back. Let's keep it real. This ruling isn't constitutional carry. It doesn't end the permit system. It doesn't force California to honor carry licenses from other states, and it sure doesn't signal the end of the fight. But what it does give us is a rare moment of legal clarity, where the court stood firm and said, no, you don't lose your rights just because you live outside a state line. That message cuts through years of legal fog, and it matters. Still, we're staring at a fractured landscape where the rules change depending on the jurisdiction. And that's exactly why so many in the 2A community are now looking toward something bigger. Federal action, national reciprocity, a coast-to-coast recognition that your rights as an American don't stop at your state border. It's not a new idea, but rulings like Hoffman inject new life into that conversation, and they do it with force. If you're someone hoping for meaningful change, this decision isn't a finish line. It's a call to action. Whether the next step comes through Congress or the Supreme Court, the objective stays the same. Eliminate the need for state-by-state negotiations when it comes to fundamental rights. Federal clarity would mean fewer court fights, fewer conflicting laws, and stronger protections for every lawful gun owner, no matter where they live or travel. So while we take a second to recognize what this win represents, let's not lose focus. It's just one chapter, and the push for national recognition of carry rights is far from over. No ruling happens in a vacuum, and in the weeks since this one dropped, feedback from gun owners, especially in California, has been honest and loud. Some see hope, others see a hollow victory. And a whole lot of folks are caught in the middle, tired of symbolic wins that don't translate into practical change. That frustration is valid, because this community isn't one voice. It's business owners working late in high-risk areas. It's veterans tired of having to ask permission just to protect their families. It's working-class citizens who don't want special treatment. They just want equal footing. And for many of them, a win doesn't feel like a win unless they can see it, use it, and carry with confidence. But here's the hard truth. Real change is slow. It builds in inches, not miles. These court wins don't always give us fireworks. What they give us is leverage. A legal foothold, a shift in the burden. They create space for the next fight. This ruling doesn't solve California's mess overnight, but it cracks the legal foundation the state's been standing on. And when cracks appear, pressure works. This moment isn't the cure. It's the signal. The wall is starting to give, but it's still standing. And that means we don't stop. Legal victories like this require follow-through. That means more lawsuits, sharper legal strategies, relentless pressure in the courts, in the legislature, and in public opinion. And that's already happening. Advocacy groups are mapping out how this decision can challenge other parts of California's permit structure. Attorneys are rethinking how they fight back against arbitrary delays and politically motivated denials. And residents are starting to realize that this ruling could help them demand the equal treatment they've been denied for years. But we can't forget how fast the state moves to regain control. Bills like AB 1078 are proof. They'll rebrand the same restrictions, bury them under new language, and tell the courts, it's handled. That's why every single policy change deserves full scrutiny, down to the last comma. Because rushed legislation passed in reaction to court losses almost never favors liberty. What comes next has to be more than just one-off wins. It takes persistence. Every new lawsuit needs to reinforce the same truth. Your rights don't hinge on your residency, your wealth, or your county. They belong to every American, equally. And no, the next steps won't be glamorous. But they will decide whether this ruling becomes the start of a new precedent or just another footnote in a long legal struggle. Wins like this don't come often, especially in places like California. And while it's not everything we've been fighting for, it is movement in the right direction. It's momentum, and that always starts small. One ruling, one clause, one legal crack at a time. If this breakdown helped you see the battlefield a little clearer or gave you something to think about, drop your thoughts in the comments, like subscribe and stay in the loop. Your voice keeps the momentum going. Stay sharp, stay principled. Rights don't defend themselves.